I think we can start, okay, in order to avoid delays. So, hello everyone, good afternoon. Thank you very much for your attendance and interest in this webinar. My name is Roberto Parrondo. I'm the Business Services Coordinator at Big Asturias, which is the lead partner of this AT Virtual project. The project, AT Virtual, is funded by the 5D Interreg Atlantic Space Program and aims to increase safety and security in maritime conditions by means of the acceleration of the digitalization process of the participating maritime safety training centers, which are entities whose mission is to train staff teams that are going to perform emergency operation in very high risk conditions. So this digitalization process will allow the centers to introduce cutting-edge solutions in the field of Internet of Things, big data analytics, and vision technologies. In simulated based training systems by collaborating with the startups of the Atlantic space who will act as digital neighbors. So in order to do that, the project has three well-defined phases. The first one is the diagnosis, which is about the determination of the maturity level of the participating maritime safety training centers in order to detect the needs and formulate the challenges that are going to be included in the different calls. So the selection phase, which is basically about launching 3 open calls focused on every digital technology, Internet of Things, big data analytics, and vision technologies, and addressed to startups of the Atlantic space who will propose probably the best solution as possible to meet the challenges proposed in this case by the centers. And the last stage is the implementation of the solutions once the pairings, the teams in this case, formed by the Maritime Safety Training Center and the startup have been completed. So in order to do that, they will have access to dedicated methodologies, so they can speed up the process, and also their tools, such as these training sessions in very key relevant topics, like the webinar that we are attending now about intellectual property rights for startups. Just to finish my presentation, I would like to introduce you briefly the rest of the partners of the AT Virtual project. We count on the participation of 2 maritime safety training centers, Centro Jovellanos in Asturias and the Munster Technological University from Cork, Ireland. There are 4 bigs represented in the project: La Valmayec Technopole in France, Instituto Pedro Nunes in Portugal, Corbic in Ireland, and CEI Asturias in Spain. And last but not least, we count on the participation of the Tecnalia Foundation, which is a well-known research institution who will assist the centers in very key activities such as the assessment of the solutions received and the implementation of the solutions. So that would be all by my side. Thanks again for your attendance, and Rui, you have now the floor. Thank you.
Thank you, Roberto. Welcome to the second webinar of AT Virtual. My name is Rui Miranda. I'm working at Instituto Pedro Nunes, a partner of AT Virtual project. This webinar, this session aims to drive startups, R&D entities, and end users on a journey of intangible assets creation and protection through a role-play case departing from the basic roots of an innovation R&D project until it reaches the market, pinpointing the most relevant steps in the process for securing the competitive advantages of the intangible assets involved. So this is the main goal of the session of today. Some rules. Please, if you have questions, put it on the chat. We will have a 5 minutes break. Okay, so after this 5 minutes break, my colleague José Ricardo Aguilar will answer the questions, and then we will also answer the questions by the end of the webinar. This webinar will take around 2 hours. Okay, with a 5 minutes break. I hope you enjoy it. Just a few words about José Ricardo Aguilar. He's graduated in law in 2000, registered lawyer since 2003. He is an expert on intellectual property rights with continuous work in this field since 2002. He is a legal advisor of IPN since 2001. Also is co-responsible for the module Regulatory Affairs and Patents at the Faculty of Pharmacy of the University of Coimbra. Is an active member of the European Patent Office, the European Intellectual Property Office Observatory, and also the European Association of Research and Technology Organizations. He's also a researcher on the Space Law Research Center. So I think this is it. José, if you are ready to start, the floor is yours. I hope you enjoy and see you.
Okay. Thank you. So good afternoon. Welcome to this session. It's a great pleasure to be with you this afternoon. So we will be talking about this topic that my colleague Rui already told you about. So we'll talk about intellectual property fundamentals for entrepreneurs. I used to do this kind of presentations since a long time, and normally my goal is to, and my audience is not composed by lawyers or by colleagues. With this, I just introduced my note, my presentation note, even if Rui already told us about. So I work in this field of IP since 2002. And in fact, normally when I deliver some talks on this topic, I used to do it to other people which are not in fact lawyers, and so I think this will bring some relief to all of you, because I imagine that the majority of you are from the science technology field and not from the legal side of these issues. So in fact, I always try to adapt my speech to this fact, and then to have a clear notion that I am not talking to my colleagues. So do not expect any Latin expressions, not so many legal references and so on. A pretty much straightforward speech, and in that sense, departing from my experience in this field, I prepared a case, a role play model case, departing from past experiences in this field of supporting innovators, supporting technology people, supporting also R&D facilities, so the science field, delivering new cases and new ventures with regard to innovation, technology, also with regard to the protection, which is something very, very important and increasingly important. And in fact, this case, of course, is a fictitious case, and it tries to come across the most frequent events, the most frequent situations that arise from this relationship that begins in an idea sometimes, an idea, other times a project, an R&D project, and it will end in the creation of a company, normally a tech-based startup company, and the process of developing and growing of a company that we can identify as such. So departing from here, this always relates with IP, with intellectual property. And why talk about IP? Because we have this clear notion that this is not the most well-treated topic when we talk about technology, when we talk about innovation. And we have another very clear idea in our minds, is that departing from our experience, most people tend to have some notions on IP, but very weak notions, very not well focused notions on IP. Normally saying, well, yeah, I'm not a lawyer, so I don't know, I don't have that need to know everything about IP. Sure. That's why lawyers exist, and that's why patent attorneys exist, in order to support you. But in fact, it is very important to dominate the basic roots, the basic fundamentals of the system. Otherwise, very tragic errors can occur, and plenty of things can be lost if the practitioners, if the people that are in the terrain, in fact, lack this kind of knowledge, this kind of competencies. And that's why it is very important to, every time that we have this chance, to recover the topic and to deliver some more talks and share some knowledge and experience with the people just like you, just like these very important projects in the European context, where people get together, R&Ds, companies, startups, entrepreneurs, in order to create something. And this is the goal, the objective of this session, is to begin with this idea and with these 4 friends that we invited to join us in this journey towards the creation of a startup company. They are Laura, Mary, John, and Albert. So we have these four people, and they will help us to set up some ideas on this. So Laura, beginning with maybe the younger member of this team, she's an aerospace engineering master student at Technical University. So Technical University, we will configure that as a public university based in Europe. A public university with a strong technical and engineering studies, and with an internal intellectual property regulation in force. So this is our basic premise, is to think about this technical university. This fake name that I got just to name our university. Then we have Mary. She's a PhD student in aerospace engineering as well in a technical university. Then we have John. John is a friend of Mary. He holds a PhD also in aerospace, but he works for XY Electronics, a company focused on electronic engineering, so another company. He is a former employee of this XY Electronics. And then we have the senior member, which is Albert. Albert is a full professor at Technical University in the same field of aerospace engineering, and is coordinating the works of Laura and Mary. So these are our 4 friends that once upon a time got this idea about something new. And this new thing, we will call it In Commander. This is the name of this new and innovative approach to autonomous vehicles, navigation and operation, based on a wearable sensor device to be used by the driver of that vehicle. So the idea, and this is, as I told you, something that came out from the mind of a lawyer, which I am. So it is a completely virtual and fictitious scenario. So they joined together, they joined some thoughts on this about a game changer solution in order to allow someone to drive an autonomous vehicle wearing only a wearable. So getting to a car, to a vehicle, to an autonomous vehicle using some kind of wearable with transmissions, with transmission facilities and so on. They could open the car and then they could sit and they could give orders to the car using that wearable. So bringing bringing all the effort to the wearable instead of the autonomous vehicle itself. So it would be a tremendous change, if it happen, of course. So this wearable device interacting with the autonomous vehicle using some kind of universal communication system and using satellite navigation software as well to guide the vehicle and to put the vehicle in the right direction, and with this sense bringing a so-called revolution to this field of autonomous vehicles and solutions thereof related with autonomous vehicles. So this team has created something that's for sure it's something new. It's something really innovative. It's maybe something with a breakthrough success, with a very promising success in the near future. So this is some kind of intangible form of creation, not yet developed, not yet physically developed, and therefore it needs to be protected. But the first idea that normally came out of these interactions with people related to a given project, to a given R&D project, is that people tend to think about IP and about the protection of their idea as something that they can do in a single shot. It's something that they can apply with a single application to have protection of the whole concept. Okay, but that's wrong. In the majority of cases, that's wrong, and that's the first idea that we need to retain from this presentation, and with support in this case that we are using here. This is a fictitious case, as I mentioned. It has nothing to do with something that I saw in the past or anything else. So people need to look deeper into the creation, into the project itself, and as I say here, people need to decompose it in layers or slices. They need to look to the project itself and see how many and what IP rights can they use to protect their own reality and the whole project. Okay, so they need to look at the IP rights available and choose which ones fit the best to protect this creation. And for this, of course, when we are dealing with our own project, we need to know at least how many IP rights do we have and how can we use them, at least in an abstract way, in order to protect at the best possible way our project. And for this, we need to know a thing or two about IP rights. So IP rights, the intellectual property rights, they have these common characteristics that we see here. So they provide legal protection to intellectual creations and assets, and they, in this sense, with support in the law, in national laws, but also international laws arising from conventions, from international public law conventions. So they provide this exclusive or monopoly exploitation of a given intellectual creation. So these IP rights, they only apply to intellectual creations, so creations that come from the minds of people, single individuals or teamwork. Normally, as we know nowadays, much more teamwork rather than individual creations, and they provide this exclusive exploitation right to the owner of that IP, and the right to exclude third parties of said exploitation. So these IP rights, they create this virtuous situation of someone being the only one allowed to exploit some kind of IP rights, and at the same time having the right to exclude third parties from that. Or if we look at it in an inverse way, they can provide rights of exploitation to those third parties, but they will then define the conditions. How, when, and how much will that cost? Especially if we think about licensing rights to third parties. And of course, if people are not willing to accept and to respect these IP rights, the owner of that IP rights can claim for legal actions against any infringer, about those that are the infringers of this IP right. And we can think, and that's the best way to think about IP. And we can think about it as something with a wide territorial scope. So not only restricted to a given territory, but expanded to several territories. And that's the way to aggregate more value to any IP that is created, is to think about a wide range of territories. So when we think about intellectual creations, at least until we definitely confirm that the machine can invent something by itself, so without the help of any human. So until we reach that state, we are thinking about creations that come from the human mind. So from our brainware, normally, as I said, nowadays, much more the teamwork brainware rather than the individual efforts of a given individual. And they all get together, creating things and turning them into something more concrete. And this middle section here is when we convert our ideas, our concepts, our only idealistic concepts into something more materialized, as we mentioned here: documents, drawings, projects, an equation, a sequence of DNA, for instance, a chemical compound, or the plan and the structure to create that compound, some data, graphics, schemes, whatever. And when we have these creations all together, then it's time for us to think about which IP rights can we mobilize to protect this, let's say, these embodiments, even if we are normally think about intangible embodiments, but about these concrete expressions of our ideas. And that's when we can then look at the different IP rights in order to protect our own projects. And when we look at the offer, the generic offer of the law, not only national laws, but also in the majority of territories, some other international based laws that are accepted as they are ratified by the states, by the different states. So we have this bundle of intellectual property rights that we can separate, that we can divide in two big families. So the industrial property rights on one hand, and the copyright on the other hand. So we can say that is improper to use the terms intellectual property rights and industrial property rights as being synonyms, because they aren't. As we see here, intellectual property rights is the whole bunch of rights that we can use to protect intellectual creations. But then we have two different families here. We have the industrial property rights, and then we have the copyright. When we talk about industrial property rights, we can generically talk about three different layers or three different areas of protection. You can think about technical features, the protection of technical embodiments, technical solutions for a given technical problem. And with this, we can use patents and utility models. In the majority of countries, patents are an industrial property right, which is defined in the law. The utility models are small patents or small innovations that are protected using kind of IP right, which is similar to a patent, but a smaller one. But in fact, there are some countries that do not recognize this right in their internal laws. Therefore, we tend to focus much more on patents rather than in utility models, because they are widespread around the world as something very stable, with a very stable regime. That's why it is easier to scale up and to think internationally of use of patents than we can do using utility models. And this is basically the most important and one of the most valuable expressions of IP has to do with the protection of these inventions. So these technical solutions for a given technical problem. Then we have the protection of the distinctive character of science. So we are thinking mostly on trademarks. And trademarks are something that we are always connected with in our daily life. Those marketing studies say that we interact with thousands of brands the whole day, since we wake up until we go to bed again. So in our journey, in our day journey, even now in this confinement, in this state of pandemic, where most of us are locked down, are working from home. Even in this case, we are always looking to brands, and that's something which is completely well known by everyone. Then a third family of industrial property rights has to do with the protection of designs. It has to do with the protection of the external appearance of a given object, and we can do that using design rights. And these are the three main areas of protection. And we are beginning to see here that we can have in a single object very different ways of protection, and very different natures of protection, of different expressions of intellectual creations that we see here. On the other hand, and before we analyze in depth the patent regime, we can also talk about copyrights as something which is related to the protection of works, together with software creations, with software as such. It is protected by copyright in the majority of European countries, even though we can think about patents for software, even in Europe, under certain circumstances, which are a bit hard to explain in such a small time slot as we have here today. But yes, in fact, we can also think about the protection of software using patent applications under certain conditions. So talking about patents, a patent is a title, as well as any other industrial property rights. They have the common note of being rights that are conferred by a public authority, and that's why we need to apply for their protection. So we need to formally apply for protection using the system, the system for the protection of IP. And this title is granted, in this case, in the case of patents, to an invention. So a novel technical solution for a given technical problem. They are awarded by the patent offices, not only the national patent offices, but we can also think about the European Patent Office as the most important entity in Europe with regard to the granting of patents. They have a time span of a maximum of 20 years, and it will only be 20 years if the applicant pays the annual fees until the 20th and last year of protection. Otherwise, it will cease its effect earlier than that. And the patent confers to the applicant this exclusive right of exploitation of that invention, or the right of conferring licensing rights to third parties in order for them to also use or to be the exclusive users of that solution, of that invention. And that invention can be a product, can be a process, it can even be something which is a new use of something already known. And in fact, this has to do essentially with the protection of novel technical features to solve a given and clearly identified technical problem. In order to have a patent, we need to comply with three different requisites. The first one is novelty. You can only patent an invention if and when that invention was not disclosed prior to your patent application. And this is relevant not only with regard to your disclosures, So the disclosures that you can control and those that you can do with regard to your invention, but also with the disclosures of any third party worldwide. And that's why it is very important, if and when we are willing to file a patent application, to search for the so-called prior art. And the prior art is the body of everything that was disclosed worldwide by every means. So academic publications, other patent applications, catalogs, websites, other kind of documents anywhere that can be a disclosure of a technical matter. And you need to take care about that, not only controlling your own disclosures, but also looking for other people disclosure in the same field. Because that's something which is certain nowadays, is that it's very easy to have people thinking the same thing, the same technical solution for a technical problem elsewhere in the world at the same time as we are now, or that they already thought about that in the past, sometimes 2 years ago, 5 years, 10 years. My record doing research, doing searches, prior art searches with researchers is 20 years. So we were looking to a project in a given year, and we found a patent application that was the full disclosure of that invention made 20 years before, which is something that I only qualify as tragic, as a tragedy, because those guys were thinking about something that in their own opinion, according to their own experience, was something completely new. Otherwise they would not doing that. They would think about anything else. But in fact, someone done that 20 years before. And for me, this is a waste of time, the waste of money sometimes. Money that could be allocated to other lines of research rather than this one, because this one is already invented. And as you know, a patent application is something that has the fate to be fully disclosed prior to any decision about granting. So the first thing that happens to an invention that is claimed in a patent application is that it is disclosed. Okay, it's published, and it will remain forever in nowadays in online databases that you can freely search and download everything that is there. So it's easy for you to use those patent databases to know better, to know deeper about your own lines of research, about your own research area. And this has to do with the first requisite for patents. The second one is the hardest one to overcome, and it has to do with inventive step. So your invention must not only be novel, in that sense that it has not been disclosed prior to your patent application, but it also has to comply with the second requisite, where the examiner, which is someone that we can qualify as a pair, so anyone with the same departing or rising from the same area of knowledge as you are. It's not a lawyer or an economist, it's someone with a technical, engineering, scientific background for sure. That is a public server working in exclusive basis, searching and assessing these patent requisites every day. So facing the most developed expressions of technology and the most innovative approaches to those problems every day. Of course, he works in a strict duty of confidentiality, and is, of course, not allowed to speak about anything that is performing analysis with regard to this. And that examiner then needs to be convinced that your solution is not trivial, is not an ordinary answer to that problem. First of all, he needs to identify the problem, and then we'll get back to our case immediately after in order to assess this in our case. So you must look at our solution to that problem, so driving autonomous vehicles in that case, and he must be surprised with our approach. okay? Because is someone with a given background, so with a strong background in the area, and we will compare our solution with other solutions available already disclosed prior to our solution, not only in patent applications, but in other sources of information, just like the academics and all the academic and scientific publications. And you will assess all that, and you will need to judge the merits of our invention, okay? And he needs to give his decision, and of course we can apply for a revision of that decision. It's not a single shot decision. That's why, for instance, in the EPO we have the boards of appeal, which are some chambers for you to apply for a given decision, especially of non-granting of a given patent application. But getting back to the work of the patent examiner, so we will carefully assess the inventiveness of our solution, because normally is the goal of a patent examiner is to refuse patent applications and not to grant patent applications, because in every case we are looking to exclusive rights, to monopoly rights that are normally granted to a privateer, to a private entity, either an individual or a company, and the right for a given period of time to exclude any other people, any other competitors from exploiting that technology. And for public power to give this let's say this privilege to a privateer, to a private entity, it should prove to be something worth of that privilege. And that's why the majority of patent applications are refused. They are not granted because they fail to overcome this two-step analysis of novelty, but especially about inventiveness, about the inventive step that invention must benefit. The third requisite is a very easy one, the easiest of the three, which is for that invention to have industrial application. So it can be replicated departing from the patent documentation by an expert in the matter. So it's very simple. So it must not depend on a given individually technical and very hard to reproduce feature or capacity of the inventor. Okay, so that's why it's easy. It's easy to overcome this this step. Okay. So as we said, and this is a kind of a summary of the three patent requisites. Sorry. So this has to do with the protection of inventions. So what else can be protected when we look to our project? We can also think about trademarks. And then as long as we think about technology, a good strategy, especially for the cases where we cannot use patent applications, because there are some legal restrictions to use patent applications to protect some areas of some technical areas. But in fact, adding a brand to our technology is a way of adding value to that, and to increase the fidelity of people to our solution, especially in those cases where we cannot protect ourselves against the competitor, especially about that competitor offering the same solution, the same feature to the public. Okay, and we are definitely thinking about every kind of service where normally we cannot apply for a patent to protect the service by itself, a business method, a way of doing business or something like. We can do it in the US for some cases, but in Europe it's completely impossible. So the law does not allow that. The European Patent Convention and the internal legislations in force in the countries. So in that sense, adding a trademark is something that can be a very smart way of adding value to our technology, to putting people, even if we are thinking about a solution which is very, very technical, and it only applies for business to business channel and not business to consumer, even in these cases, we have people deciding what to buy and what to follow. And in that sense, it's a very effective strategy to add a trademark to our project. Even, as I told you, even if we are thinking about something which is pretty much technical. Then you can also protect the design of the external appearance of a given object, regardless of being kind of posh or statical object. But you can expand the boundaries of this IP right to technical objects, to functional objects. In that sense, we can add an extra layer of protection, or a secondary way of protection, even in the cases where we cannot combine a patent application with this, or in those cases where we can like close the circle around our project, adding this other layer of protection. Then the copyright. The copyright can be used essentially to protect works, so texts, figures, drawings, and so on, and other creations in that sense, but also the protection of software as such. So software as such is something that we can protect using copyright. Copyright is a very unique IP right because it is the one that doesn't need any kind of formal registration in order to be opposed to an infringer, to a given infringer. You only need to prove that you are the owner of that copyright in order to pursue any infringers. So of course, using the legal actions and all the measures that are defined in the law. So always working in the legal side of life, not in the illegal one, even to chase any infringer. But for sure, it is an IP right which does not depend on any formal registration, even though we have ways of registration of copyrights, but they are mostly related with stronger proof of authorship or of the detention of copyright, and to get our position stronger than without any kind of measure like that. Okay. Then there's a last layer of protection, which has to do with trade secrets or industrial secrets, and this is something that we can apply for protection for all the remaining information or know-how detained by a given team, by an entrepreneur, by a university, by someone that relates with a technical feature, or it can be related with commercial situations, commercial data, so client lists, plans, ways of doing things. So it's a very, very wide category of assets, of intangible assets that can be protected as long as they are treated as something confidential and benefit from an effort, from a given effort from the owner to turn that and to keep that information confidential. Okay, and this is more and more important category of IP, even if we are talking about, can we say, a side IP thing, which has to do with all the information that is not part of a patent application, that is not protected in any other way. And nowadays, more and more important at the European level, due to the approval of the 2016 European directive related with the protection of those industrial and commercial confidential information. So this brought a very stronger focus to this feature about the protection of know-how. Okay, so this is a summary about all the IP rights that we've talked about. So we have patents, protection of inventions, technical solutions, with a time span of a maximum of 20 years, with the requisites of novelty, inventive step in the industrial application, and with the need of a formal application in order to get the protection of this invention. Trademarks, the protection of signs as something that can have a distinctive character and something that we can put on a given product or to identify a service, from those that are similar, that are the same product or service, or something which has some affinity with that given product or service. This IP right is the only one that can be eternal, in the sense that you can, every 10 years, you can renew them. So you can renew the protection forever. And that's why we have trademarks with more than 100 years, because they were registered more than 100 years ago. And that's something that happens elsewhere with those very famous trademarks, those that are one of the most enduring assets of a given business. And that business can turn itself up and down several times, but some of them, the most valuable asset is their trademark, their brand, and that brand, of course, needs to be protected. The requisites for the concession, so it has to be available only, and it's not an idea of the given trademark to be novel, but the idea of being available in a given territory. So it's a very important thing for you to assess the availability of a given trademark in the territories that you want to exploit. Nowadays, this is a much easier task, because there's a very powerful database that aggregates the majority of the results of trademarks that are protected in the majority of countries in the world. So nowadays, it's easy to use those trademarks to assess the availability of a given trademark. Okay, protection of design, so the protection of statistical characteristics, of external characteristics of a given object. So the protection can last at least a maximum of 25 years in Europe. You can apply for EU protection as well as trademarks, and the EU agency, EU IPO, the agency headquartered in Alicante in Spain. As long as you have novelty and singularity in those characteristics, and the same, you need to apply for that protection. You can do that online. And the last one will be copyright. So the copyright has the protection for works, also for software and for databases. And the time span of the protection will be the author's life or the creator's life plus 70 years after his death. So it's a long period as well, not so long as a trademark can be, as we saw. This protection is valid without any kind of renewal application, as I mentioned, and it has to do with originality. So that's the basic concept and the basic requisite for the protection. So let's get back to our project, because we were in this role play case, and we are back to our In Commander project, and now we will try to see how many IP rights and which IP rights can we mobilize to protect our project. Okay, so we have this new and innovative approach to autonomous vehicles navigation and operation based on personal wearable sensor device to be used by the driver. So this is kind of a title of something which we can qualify as a technical solution for a technical problem. So the technical problem is to turn a vehicle autonomous, so to be self-driven. And in that sense, we have a new approach to this. So we can have a patent application here, or we can have several patent applications, as long as we have different inventions bundled together in order to allow this operation of having a wearable that will unlock the car and that will give instructions to the car. So instead of us putting instructions in the same car, so an universal way of driving things and so on. So it should be kind of a rocket science stuff, but in any sense, this can be the true area of application of a patent, can be here in the protection of these solutions. Then we have here a wearable device. Okay, so wearable device that interacts with a car, so something with an external appearance, that we can work in order to be something with some sexy appearance, with some sexy characteristics, and in that sense we can protect its design. So using design protection here. Then we have navigation software altogether. So we can think about this software as something isolated, or the majority of cases it will be embedded in the patent application. But if we think about the software by itself, we can use copyrights to protect it. And then we have our name, our brand in Commander. And here we can use trademarks. Okay, so we see here that this very promising project that we are thinking about is a project that can be protected in all these ways, in using all these IP rights, rather than looking at the project and think that we can have a single protection for that project, because that is impossible in the majority of cases. And this is the big lesson that I want you to take from this first part of this presentation, is that we need to look at the system, and we need to pick which are the best ways of protecting. Because sometimes we cannot use so many IP rights. And in fact, I choose this case because it would be sufficiently plastic in order to use the whole spectrum of IP rights here. And we can also have some know-how related with all the working part of this solution as something that can constitute an extra layer. That one related with trade secrets also, that can be here used in the same sense. Okay. So in a kind of last note of this part, we have 4 or 5 ways of adding value to the project. So patent application for the novel technical features, a trademark for the iCommander expression or the iCommander phrase or name, design protection for the device itself, for the wearable, at least for the wearable. That's something that people could use and see to the other people and show to the other people that they are very modern, so they can drive autonomous vehicles using only a wearable. Then software protected with regard to copyright, and some trade secrets as a hidden advantage that we can use in the same area. Okay, so here we have our IP rights, but then there's something always painful, which is costs. The costs of filing IP applications, and here we can look at it as an ongoing process, and this is very important. And we will, in the second part of our presentation, we will look with deeper focus to this point, especially when we think about patent applications, because patent applications is a very lengthy process. In fact, it's a process that normally takes 3-4 years until its final completion. So until the final decision of granting or refusal of that patent application. But during this process, this time period, you can postpone the heavier costs to the end. And this is it's a very, very important advantage, especially when we think about startups, when we think about these new ventures that normally they lack one thing, which is money. They have a very good idea, but normally they lack money. So in fact, with regard to the beginning of that process, with the beginning of a patent application story, it can begin with, I would say, in a very honest way, 2,000 euros. And this 2,000 euros will cover not only the fees, the patent fees, the application fees, but also the work of a patent attorney. A patent attorney is the one that will convert your sexy and your very promising invention into something that can overcome that exam, which is done by someone from the same area. So that that work of the patent attorney is fundamental for you to have a strong patent document one that can overcome this, especially with regard to the claims section, which is the most important section of a patent application, is the claims section. And to write powerful and strong claims, normally, in the majority of cases, you will need the help of a patent examiner, of a patent attorney, because the patent attorney is trained to write that and to convert your description, which can be, of course, of high level, especially if you are deeply involved in research. So no discussion on that. But transforming a good description into good claims is normally something which is not very easy for a newcomer to the system. Of course, as long as you already have 10 patent applications and you are quite used to fight with the examiners and so on, maybe you'll be very much in a position of writing yourself the claims and only ask for a quick revision from the patent attorney. But as early adopters of this of patent applications, for sure you will need that. And that's why I estimate this value for month 1 for the kickoff of that process, especially remembering that you are not allowed to update your patent application. So your first patent application will be your last one. And if that first patent application is not a good one, so you will lose your chance to have a good protection. Okay? Then you will only be asked to spend more money with your patent application 12 months after. And here you will have the need for 2.5Ks in order to assure the extension of your patent application to the international phase. So to turn that into an EP, so restricted to Europe, or a PCT patent application, so one that is internationally, so with a worldwide expression or intention to protect. Then you can postpone until month 30, so 2.5 years after the beginning of your patent application, normally with a national application on your home country. Then you will need a lot of money if you want to protect your invention in a given number of territories. And that can be 100 years, 100,000 euros, for instance. It's easy to spend that money. But in fact, you have 2.5 years to search for that money. To search for the money, for instance, with near a venture capital firm, near a business angel, near someone that can assure you have the money to pay these expenses. But the idea to have here is that you don't need to have this money in the month 0, in the kickoff of the time where you need or where you want to have a patent application filed. In that moment, you don't need to have 100,000 euros. You need to have 2,000, and 2,000 can be a good number and a very balanced figure for you to kick off a good patent application. Okay. When you think about trademarks, you can spend around 1,000 with regard to an EU trademark, and with regard to design protection, you can spend 350 euros for the protection at the EU of a given design. So as you see, there's some money involved here. Of course, with regard to patents, you need to pay the annual fees in each territory. So this will top up on all this money that you need to have to assure the protection. So then the EPO will claim you annual fees, but also each country will ask you to pay. And if you forget to pay any of these annual fees, you will lose the patent in that territory. Okay. So this has to do with IP. And as we are reaching now 5 p.m., it's time for us to break. And as promised, I will open up the chat and I will see if we have some questions here. Okay. We don't have questions yet. If someone wants to put a question now, I'm more than happy to try to answer them. And after that, we'll make a short break and we'll resume with the second part. Okay? Any questions? Or if you prefer, you can open your microphone and put it orally, if you want.
Yeah, if you want, we can let
Yeah, yeah,
you put the question. So, but if you don't have any questions, you can do it later.
Okay, we have one.
And,
The only way to register software is via copyright. No, in fact, there's a way of claiming protection for software using patents, patent applications, even in Europe. In the US, it's easier because the US system is much more open to patenting than the European one. European law is much more strict with regard to the cases that they allow for protection using patents. But in fact, you can use a patent application even in Europe as long as your software provides a technical effect, provides and creates something which someone in the area can qualify as a technical effect. And maybe I can illustrate that with a short example, which is an example which is public knowledge. That's why I am allowed to share this with you. This has to do with one of our startups based in our incubator, nowadays in our accelerator. That is, so they are specialized in enhancing image technologies for surgery and for guiding surgeries. They are called Perceive 3D or P3D. And they have a bundle of patents covering algorithms and software solutions to enhance in real time the image that is collected by surgical probes. Okay, so they can correct the image that the surgeon is seeing in real time. So this software was patented because it proved to have a kind of technical effect, which is the manipulation of an image in real time. And this was qualified as a technical effect, and therefore was protected as a patent application. Okay. Then the second one was the protection of business process or business method. So in Europe, you can't do that. In the US, you can, under some certain circumstances, you can, but of course that patent application is only valid in the US. So you can only claim an illegal action against an infringer if that infringer works or applies that invention, that business method, in the US territory, okay? Then scientific paper or PhD thesis in which topic will be. Okay, so I imagine that you are asking, so Janir is asking about ways of protecting a scientific paper or PhD thesis. Of course, when we think about this, we talk about copyright. We can also think about a PhD thesis or a scientific paper that also further discloses an invention. And in that sense, it can be the basis for a patent application, but only that part where it discloses that invention. But all the layout and all the ways of expression, the idea which is behind the thesis or the paper is protected through copyright. Okay.
Jose, I don't know if you answered the second question of Johnny too. Can a business process?
Yes. Yes.
Okay, sorry,
yeah.
I didn't get.
Okay. So any more questions? Okay, if not, we are doing a 5-minute break. So we'll resume at 5:15. Okay. So see you in 5 minutes, 7 minutes. Okay. Thank you. Okay, so we're back. So let's resume. We have an additional question about so you're now in our chat, still related with IP. So it says advanced and registered software. In case the software copyright is registered, would you consider that software itself would be considered as registered or need to be patented? Well, when we are talking about software registration, maybe we are thinking about those deposit or escrow contracts that allow you to make a deposit of the source code, and in that sense, so the rationale is the same. These registrations, they only so their mission is for you to enhance or to turn or to get a stronger link of that software with you or with your company. So all these registrations of software, so they perform this utility of turn that relationship stronger between the owner and the software itself. The patent application is another thing, is the use of that software, or to see that software as a technical solution, so something that creates a technical effect in order to solve a given technical problem. So that's something completely different. And in that sense, you can have both protections. You can have that software in its basic roots and utilities protected through software, and you can have a patent application as long as that software provides a technical solution for a given technical effect. Okay, so these are different plans and different scopes of protection, even if they are applied to the same asset, to the same software. Okay, so I hope this question is also answered. And now, so we can proceed. We can carry on with our second phase, and so we will get back to our case. We will get back to our friends, and we'll get back to our iCommander project, which is being developed by our friends. Okay, so where does this project came from? When we think about this consideration of the roots of the project, normally we think about R&D facilities. So we think about universities, we think about R&D centers, about polytechnical institutions, or other R&D facilities. And normally these facilities, they are public funded. Either they are part of the public infrastructure, or at least normally they are financed, they are funded by public funding. Okay, and normally these universities, and we as we mentioned in the beginning, so we are considering this technical university as an entity with an IP regulation in force. So we are thinking about that, and the first concern that we have, when we talk about technology and assets, technological assets under development within a facility like this, is the management of academic publications by far. We are thinking about something which I used to joke about this with my students in university where I give classes on IP. I used to say that academic publications are the first cause of death of patents, especially in Portugal, but in other countries it can happen the same, because people are not pretty much aware of this requisite of novelty. So you need to have novel technical matter in order to patent it. Otherwise, so if you if you already publish that, for instance, through an academic paper, through a thesis, through a poster in a congress, you will lose novelty. Okay, so this is a clear and present danger to any intention of having a patent, and that's why you need to carefully assess these publications if and when you predict that you can have a patent application. And for sure, we know that people need to publish in order to pursue their goals in their academic career and so on. But the question is, we can smartly use the system in order to give the proper priority, especially to the patent application in comparison with those academic publications. So sometimes anticipating the moment where when we apply for protection using patent application, and then making all the publications only after this moment. And that's the proper way for you to manage both scenarios and then to reach a so-called win-win solution, where you assure the protection of your invention, but you do not close the door effectively to those academic publications. And this is a very strong dilemma, which go across all the inventions, all the technology that is being developed in the universities, and that's why you need to take this into account effectively, because otherwise sometimes you will lose the chance to protect things. Then another thing which can be a threat to a project like this, if we think of this project as something which arises from research developed in the university, in whole or in part, is that sometimes the same university was prior engaged in, for instance, R&D consortium projects with other entities, those Horizon 2020 projects, for instance. And in that sense, sometimes those consortium agreements, they reserve some rights, or they create some conditions for third parties to retain IP on something that we, in a first analysis, would think that would belong to us, or that we could mobilize to this project. But sometimes this will require some negotiation, this will require some talks, some prior talks with third parties, especially those that were involved in prior agreements with other parties. And this is another thing that will need a careful assessment when we are using R&D as a basis for a new business and for a new company, as we are foreseeing here in our case. Okay, so this is another point, very important point when we think about university-based R&D. So our four friends, they intend to explore the project. They intend to turn this into a marketable solution, into something that they can exploit by themselves, or they can in the future get the interest, for instance, of Tesla or of Siemens, of any other automotive or mobility player in the market, worldwide players, and something else. So the goal normally is the creation of a startup, a so-called spin-off company, to take the iCommander to the market, or to turn iCommander into something closer to the highest TRL levels. I think you are pretty much aware of what TRL levels are. So these technology readiness levels, and sometimes these companies, these spin-off companies, are the ones that will fulfill the latest stages of development of a given technology towards the market, and turning that into TRL 8, for instance, or 9. So the highest point, just the closest point to the market, or even the market itself. So the idea is the creation of a company where Albert, John, Mary, and Laura will be the shareholders. And if we think about the company which is detained by these four friends, we need to look at each one of them. So when we talk about your case, you'll need to look at your team, at your own team, to see if your team is free to do this, or if any member of your team has some kind of I would not say problems, but I would say circumstances which require some prior assessment and some prior decisions in order to turn this phase or this movement towards the creation of this new company as to something legal, as something which is completely framed by the rules in force, and as something that people are free to do without any kind of threat or harm around them. So, talking about the professor Albert, so the senior professor, the full professor, he must be aware of his duties as public employee. In fact, he has an employment contract with a public entity, which is the technical university, this contract normally can bring some exclusivity duties. And if Albert wants to become manager, formal manager, or legal representative of this company, he needs to ask for a prior authorization from the rectory, normally from the rectory, in order to combine this new occupation, let's say it like this, with his duties as a public server, as full professor. So this is a very, very important point in order to give a formal authorization, which has nothing to do with the position of shareholder, because of course he can be a company shareholder for sure, but I am addressing specifically the case where he wants to be the legal representative or the manager of that company. So in that sense, you need to be careful on this, especially when you have a public employment contract. Then John is working for another company. And nowadays, as you all know, people tend to rotate more frequently between jobs, between occupations, between projects, the so-called project economy. So a very different model, very different trend when we think about past times where people would have an occupation for their whole life. Nowadays, that's not a trend anymore. So he must take care of his current employment contract in order to assume this new position. Especially exclusivity duties, confidentiality, and some IP assignment rules that he can have in his on his current contract. And normally people must be aware that forming a new company, of course, they can do that, but sometimes that can be a violation of some rules of non-competition and things like that, that may require this person to resign to his former position or to his actual position in order to assume these new functions. Okay. Then about Laura and Mary, they are students, both in different levels. So maybe they are bound by the IP internal regulation in force, for sure, but they are much more free to form a company and to have this new venture. But even in this case, they must be aware of their duties as scholarships, especially if they get a scholarship fee, because sometimes that also brings some exclusivity duties at the same time. So they must be aware of that as well. So people must look at their own situation, so they can be freely and completely legally framed in order to assume these new functions in this company. So I Commander Limited, the new company. So the company created by these four guys. This project, and I have here this phrase, because this is very important for the promoters of a given startup, especially when they are coming from the university, when they are not coming with an individual idea, with something that came out only from their minds, from their joint efforts, from their homework. When that's not the case, especially when they began to work on a given technology in the university labs, the university facilities, or challenged by some kind of studies that they are performing. In every other case, they need to assure the so-called freedom of operation. And I am constantly looking and advising people to be very, very aware of this when they launch a company, as long as they are coming from any university. So in this sense, this new company must be awarded with a formal license from the university when they are using university's IP. So sometimes these people are bounded by the IP regulation in force, so that IP regulation will define that some or part or the whole IP which is generated by their work in the university belongs to the university. But the university, on the other hand, is completely free to license that technology, that same IP, to those guys, because they are the most interested sometimes in the promotion of that technology or into crossing that path towards the market, especially through the creation of a spin-off company. And in that sense, you need to have this formal recognition of your university, of your home university. Or sometimes there are scenarios where several entities are combined in a single project, or the IP which is used in a new company is coming from different entities. So in this sense, you need to have a formal document allowing you to use this IP. So this is a very important point. Okay, and I will address again this point in one of the next slides when we talk about other step of development of this company. Of course, this negotiation will require you to define a fair and reasonable compensation to the university, as long as you are mobilizing, especially through an exclusive license, the use of this IP in your own benefit, because you are using in the benefit of your private company, and normally a company where the university does not have any kind of shares. So the university will accept to celebrate an agreement with you where this company in the future, and of course not in the early beginning, because in that phase that company has not any way of paying any kind of royalties because they are still working in something which is yet to come to the market. So later on, they need to pay royalties to that university, because that's the only way for you to grant back some of the privilege that you are earning by exploiting this IP, which is generated by the university. So it is generated by public funds or financed by public money. So you need to grant back some of that money using the royalty scheme. And in this sense, this is a virtuous thing, because this will bring the recognition of the university as the source of a new company. And it, as you know, it is very important for institutions like Instituto Pedro Nunes, our incubator, to host companies created by past researchers, by teachers, by people from our university, because this is a way of retaining talent in the region and to create new qualified jobs in the region for this company, if and when these companies will still be headquartered here in Coimbra, in our region. And this happens elsewhere in Europe. So this is a trend. So the stimulus for the creation of these companies. But we need to see these companies as a way of the university to pursue its public interest as well. So companies that are created to take technology-born, university-born technology to the market. And the vehicle will be these kind of new companies, where people are willing to take some risks, and people will risk this activity. Of course, some of these companies will not be succeeded, but some of them, they are very well succeeded. And they will generate very nice revenues to the university in the end of the day. And this is the trend. So the creation of these companies being allowed and being formally recognized by the university. This is a very, very important point, in fact. So then iCommander starts operation. And with regard to IP, always a concern when we think about a tech-based company, you will need to have one person or more than one that will be in charge of the management of IP, not only the applications, but the new registrations, the new cases, and in any case, you need to mobilize someone to be the contact point or the contact person for these matters, especially when you think about all the things that you need to take care with the patent attorneys, for instance, with the guys that will represent you towards the patent offices. So you need to designate the so-called CIPO, so the chief IP officer. Of course, this is not sometimes, in the majority of cases, a 100% occupation, but the trend here is to nominate someone that can answer to all these questions, that can have an up-to-date process of all the IP regulations, or of all the IP applications, all the IP applications that you are currently applying for protection, not only in your home country, but also abroad. Another thing which is critical is the management of your information. As I told you, there is a very large amount of information which is of critical value to you. So you must assume confidentiality as a rule, and you must formalize that using the so-called NDAs, or non-disclosure agreements, anytime that you need to disclose information to strange people, to those that are not the core of your company. And then also with regard to the relationships with your staff, with the people that work for you. So you need to assure that IP belongs to your company, regardless of the framework where some people work for you, either as employees or consultants or even scholarships or projects related with consortiums and so on. So you need always to address this topic and to turn this as something which is the concern for the safekeeping of all the biggest part of the value of your company, because that will rely heavily on your IP. And we can think about IP not only about patents, trademarks, and so on, but also about those trade secrets, about all that information that normally can be the basis for future IP applications. But in other cases, it is valuable by itself, as long as you can retain that information indoors inside of your own facilities. Then some of these companies, and I would call back the case of that company Perceive 3D, P3D, our incubated company. IP portfolio must be seen as an ongoing process. So the idea for you is to constantly innovate, and therefore to constantly apply for protection of new things. But in fact, in the early stage phase, you may lack funds for this. But nevertheless, you need to set up a strategy. You need to have a strategy, especially thinking about medium or long term. And as long as you will get some money to invest some of that money in the protection of IP. And sometimes these very intensive, IPR intensive companies in the early stage phase, they tend to spend lots of money of their budget protecting things. But then as they begin to generate more and more revenue, so the percentage of investment in IP, of course, will be diluted. But in the first years of operation, for some businesses, it can turn up to 20% of the costs, of the whole costs, of the expenses of the company, can be related with IP, as long as IP is important or is critical for the position of the company. Okay. One other thing which is very important is to think global. There's no use to think about IP without thinking about international markets, about international protection, following your efforts to be a born global company. This is the trend for our companies, for sure. And nowadays, especially in this digital environment, this increasingly digital environment, companies will tend to look more at the global market rather than an internal domestic market. And therefore, the efforts for protection must follow this trend, and they must be in parallel with all those markets that you want to conquer. In that sense, you need to look at international protection of your IP as something which is a central concern as well. Then another thing that you need to do is to seek for incentives for IP protection. There are plenty of them. I would highlight one very recent one, part of those post-COVID-19 measures launched by the European Union. So nowadays you have an incentive for the protection of trademarks at the EU, together with design protection that will cover half of the fees that you need to require for protection. It's a very easy system that you can assess throughout the EUIPO website. But also other incentives that are related with R&D. So previewing some money, some funds to take care of these costs, because these costs tend to be heavy. And we are pretty much aware that in the first phase of the company, normally people lack funds to everything. And of course, they will lack funds also for IP protection. Okay, then what happens next? Your company starts to grow, but you still lack money. You still lack funds to expand your operation. So you need to begin. So it's a phase, a normal phase of growing of a company like this is the relationships with venture capitals and business angels. So once they've heard the pitch made by you, by one of your member team, and so they were interested in this project and they are willing to put some money here. So they will do the so-called due diligence process. And what is this? Sometimes multidisciplinary work done by a team combining lawyers, economists, people from management, so several people all together, in order to do an X-ray to your company, your new company, to see if there's any problem, any constraints on your operation. And then, as long as you face these guys with lots of money, that this money, of course, is scarce and is being challenged, disputed by people everywhere, by other innovators, by other entrepreneurs, they will, for sure, they will ask you for an IP strategy. And this is turning more and more a concern by these guys. And the second point is that they will be extremely concerned as well about that freedom of operation that I spoke about 2 slides ago. Okay. If you fail to deliver a reply on this, maybe they will lose interest in your project. Regardless of being a very, very sexy project, they will turn into something which can be a safer harbor for their money. Because if they see that, okay, you are coming from the university, you have an employment with the university, but now you are saying that you are free to deliver, to have this project and to turn this into a company, why? So same question arises. Does this come from your garage or not? Or does this come from the university bench, the labs? And if so, why don't you have any kind of, at least a letter of intent, something that can prove your freedom of operation, your willingness to be here as a privateer working with this technology? Okay, I followed several negotiations like this in the past, especially with regard to boards of evaluation of projects and so on. And sometimes this is a no-go. This is a no-go for these projects to get.
No, pero necesito así porque si no, no calza. Dale.
Sorry, can you turn off your microphone, please? Okay. Okay. So I was telling you, sometimes when people fail to deliver a concrete answer to this, or a substantial answer to this, sometimes this is a no-go, and people tend to look at this as a highly risky bet, because quite soon that university may show up saying, well, these guys are not entitled to be here, and we will sue them, we'll put them in court, and they will face some accusation of, in the end of the day, stealing things to the university, still using public things to private ventures and so on. And in any case, people need to avoid a situation like this. And that's why it's very, very important since day one to talk with the TTO, with the Technology Transfer Office, to be open on this, on your intentions, because the university will also, normally the university will want to follow you, will want to be on your side, so supporting you and seeing this as a positive approach to have this new project running. And that's why you will benefit a lot from playing an open game with your home institution, okay? Then the expansion of the operation. So now I Commander company already got an investment, a heavy investment from a VC, is now running in cruise mode. As I told you before, IP and confidentiality must be present in each and every agreement that you celebrate with staff, taking into consideration this high rotation of people. So people are working to your company now, but maybe in 1 year they are invited to join another company, or they are challenged to launch their own company. And you need to be sure that everything that they are being paid to do in your company will belong to your company, okay? And no questions on that. Remember John, remember one of the founders of the company, he was working for another company and now he's launching this company. So sometimes when people look at their own cases, they will see the danger which is surrounding this kind of relationships. And that's why you need to carefully assess this, and since day one to have proper agreements in force with everyone that works for you, regardless of the formal way of engagement of those guys, okay? Employment contracts, consultancy, whatever. Then to have IP ownership rules in every contract with third parties. When you think about contract research, when you think about consortiums, about the acquisition of technology, whatever, to have a serious bookkeeping activity and information lockdown in all your internal operations. So a good memory on everything which you can see as valuable information to register it, to retain it, and to have proper measures, because that's the only way for you to claim protection with regard to those rules arising from the directive, from the 2016 directive, is for this information to be defined, identified, and targeted as something confidential and protected by effective measures directed to assure that confidentiality, okay? And of course, when we think about those relationships, those roots, relationships with the university behind you, behind your company, to keep these records of all the licensing obligations in force. So being very serious on this point as well. Then, with regard to the expansion of your IP, of the IP of the company, or the IP of iCommander company, making prior art searches every time is a duty of work, as an internal operation, a proceeding, a constant proceeding. So the use of these databases, some of them are free, as you know, SpaceNet, managed by the EPO, or other databases that you can subscribe, those paid ones, which are, of course, much more powerful. So with this, being aware of the majority of IP and prior art around you. With this, you can avoid redundancy. You can avoid to spend money, the precious money of your new company, researching things that are already disclosed in patent documents. And this accounts for an average of 25% of all the money that is spent on R&D in Europe. 25% is redundant, which is a scandal for me, because this is a total loss of money, especially because people do not have this habit, this trend of making these searches. With this, you can assess all the surrounding landscape. So you can assess your competitors. You can do some mining of the activities of your competitors. You can predict what will be their offer in the next 2-3 years, looking at their published patent applications? Because normally, as you see, patents are applied, are required quite early in the development stage, as long as people need to discuss things, to make scale-ups, to make prototypes, to involve third parties, to involve suppliers. So everything require people to anticipate the moment where they will patent that new invention. And therefore, looking at the patent databases will allow you to understand earlier which are the movements of your competitors. Another thing which is very important when you do this is to prevent third-party IP infringement, which is something that can be the end of your company if you face a legal action with regard to IP. And I strongly remind you that during this year, probably, we will have in force a new kind of patents in Europe, which is the unitary patent. And that's a patent that will be enforced in almost every EU country automatically with a single application, with the exception of Poland and Spain. But the remaining body of EU countries will be covered by a single patent application. So this will bring an increasingly number of legal actions against patent infringers, especially in countries where this is not the most developed topic, just like in Portugal, but other southern countries, which are not so much aware of the value of a patent. They can face legal actions, and they will be facing legal actions in the next 5 years, if and when this system is enforced and everything turns as something that will happen during this year already, okay? And in fact, this can be something a bigger concern for your company and for a company like iCommander. With all this work, you will for sure read other patents related with your field of application, and therefore you will be prepared for drafting your own patent application. So you will be much more experienced and skilled in the art of writing patent applications. So therefore, reducing your fees with your patent attorney, because you will be much more and more independent managing these processes. And that's why this is another way of extracting value from this activity of prior art searching. Okay, and this is very important to follow all the R&D that you are currently developing in your company. Then look at iCommander as a company that is strongly concerned on IP. So look to all the ways that you can use to extract value of your generated IP. So selling some of your IP or part of your IP or all of your IP, licensing it, so conferring rights of exploitation to third parties in the conditions that you negotiate with them, normally paid because it's a company, so you are willing to earn profits of your activity. Creating a spin-out. Sometimes companies, so they isolate part of their activity into a new company, into a separated company, because sometimes that's the easiest way of extracting value from that. Then also consider licensing third-party IP, so IP from other entities, in order to enrich your offer or to combine that with your own portfolio. Of course, be active on the prosecution of potential infringers of your IP. There's no use to protect IP without a strong vigilance of the market. And you can do that by yourself or asking for a third party for a specialized assessment of that IP. So making your follow-up of this activity. In this sense, you can turn your company as one of the IPR intensive industries in Europe. So we can look at this iCommander and to your company as, if you do this in a very focused way, you can be one of the IPR intensive industries in Europe. So you can can be part of those companies that account for roughly 26% of the employment and 39% of the GDP in the European Union. as we learn in some studies, especially those published by the EPO together with the EU IPO, with regard to the use of IPR in Europe. So these are the companies that definitely add value to the European economy, are the ones that strongly bet on IP. And that's why when we talk about technology intensive companies, there's no use to talk about that without talking about IP. And this linkage between these two worlds or these two features is increasingly important, even though we know that in some countries, just like Portugal, this is not the most developed topic. And that's why it's very important to have this message. And that's why it was another way of bringing this topic to this enlarged universe of people engaged in this very interesting project, just like RT Virtual is, and turning this knowledge into your future operations of your future companies or your already developed ongoing companies as something that will for sure will add value to your projects. So this was a pleasure to be with you this afternoon. We will have another time, another slot for questions. We already have here some of them. I will try to address. There was a past question from the first phase from Eduardo Linho, which was, can a mobile app or web platform be protected by design? So normally we think about design for objects. Normally it is not applied to software creations, but in a remote use of the system, maybe we can do that. But in fact, normally that is protected through copyright. So those mobile apps, the layouts, the colors, all the user interface, normally that's part of the protection of software as defined by copyright. Design protection is much more focused on the protection of the external appearance of objects itself by themselves. Okay. Then Rosario. Maybe this question has to do with the course, for becoming a patent attorney. Yes, we have some trainings in Portugal, and to obtain the title of patent attorney, you need to do an exam near the patent office in Portugal. So entitling you to present yourself as a specialist in the management of IP processes near the patent office, the patent trademark office. This is very important because this allows people which are not lawyers to represent clients near the patent office. Of course, not to show up in court because that's legally a duty of a lawyer working as a lawyer. But a patent attorney in Portugal can be an engineer, can be a pharmacist, can be a doctor, so can be anyone with a technical background, also economics, and of course legal background. They all can apply for the title of patent attorney. And yes, it's a formal recognition by our patent office. Even if that recognition has to do with private functions, of course, because these are privateers, private players in the market, so supporting clients in the filing of IP applications. Okay, then if we are going to share the presentation from my side, yes, Rui, I think
yes,
that's part of our business. So yeah.
Yes,
sure.
We are going to share the presentation. Sorry, Jose. We are going to share the presentation to all the people that attended this webinar. We will send an email with this information. Okay.
So mining company who's in charge. So who'll be in charge? I think we were talking about the CIPO, Janir. Yeah, of course, we are thinking about, and this case was much more related with technology intensive company rather than a classic or some company which is mostly focused on traditional sectors of the economy. So that's why, yeah, we are thinking of much more on technology intensive and innovative companies rather than that case. Liliana from Dom Assistance, incentives to protect IP. There are some measures, yeah, not only national measures, but also I was thinking also about projects, about R&D projects, and to preview in their budget some money for IP protection. It's important because that's a way of you to cover those patent attorney fees, for instance, which are heavy, especially in the early beginning. So my point was just to look around you and to see any way of getting some money, trying not to forget the protection of your IP, okay? Then IP strategy document. Okay, this can be a guidance document. So some thoughts align, some brainstorm inside brainstorm in order to see what can you do to perform better with regard to IP. What can be the internal measures? What can you do to strengthen the position, to turn it stronger, the position of your assets, of your intangibles? What can you do with regard to third parties when you try to interact with them? When you have projects with third parties, what can you do to assure the IP? What should be the concerns? So there are plenty of things that you can look after when you talk about an IP strategy document. This can be also can take the form of a pre-diagnosis document. So there is creativity is the trend here. So you can look at this from different angles. There are plenty of things you can do on that. Then Michael O'Connor, how do you clean up background IP before taking over IP and registration and registering new IP? Okay. Okay. Maybe we are talking about assessing what can be a threat to your new registration of IP. Well, if that's the case, okay, you need to see if there's any kind of agreement with third parties retaining some IP rights. There are plenty of things to look after in order to assure that you are free to register your IP. Former employees, past contracts, past agreements with third parties, information that was disclosed by you or by your team throughout papers, throughout academic publications, plenty of things that you need to look after in order to assess properly if you are free and if you will be succeeded in the register of new IP. Okay. Any more questions?
Okay, Jose, thank you.
Okay.
I think there is no more questions.
Okay.
Okay, so
it was a pleasure. Once again, thank you. And then I will send the presentation to Rui, and then it will be shared. Maybe through last question. Who should be in charge of IP matters in a mining company? Okay. I would say someone close to the top management. That's fundamental in every case. Okay, someone that has some power to persuade the top management to take care of this issue. Okay, and not to leave this issue unattended. That's important. So maybe that's the only answer that I can honestly provide is to be someone that can closely work with with the top management, with the guys that take the decisions of the company. Okay.
Okay, Jose, thanks a lot for your presentation. I think it was very interesting. So this was our second webinar of AT Virtual Project, sorry. We will have 4 more webinars, so keep in touch. Follow us on our social networks. You can look for the new webinars on the website, our website as well. So looking forward to see you again. Again, thanks, Jose. Thank you all for
Yeah, it was a pleasure.
Okay.
Okay. Thank
Okay,
you.
bye-bye.
Bye.
Have a nice
Bye.
week.
Thank you.